topics and a couple of things that have come up a few times. So first I want to start with the sort of search and seizure rule that a number of people are concerned about. I think there's a lot of misconceptions about it, and I want to make sure I can set the record straight on that one up front. The first point is that the language originally from the search and seizure rule, and I'm going to call it that in shorthand, came from the HISA Act itself, which was not written by us, and as you all know, was passed by Congress. We have absolutely no intention at HISA, and I'll get into in a minute and more the specifics of the rule. We have no intention of searching people's homes, farms. We actually don't have the intention of hopefully having to use that power at all. But we, on our own accord, even though the FTC approved the original broader rule, narrowed the rule to only apply to civic covered horses and covered horse races, so that really the only way that you would see us ever exercise that power is if there is a serious horse abuse issue, a serious doping issue where we need to actually go and follow the horse. And I hope that if we had an occasion like that, which would be an exceptional circumstance, that all of you would be supportive of that, because it would really be to do what our job is, which is to protect equine welfare and also rider welfare and safety. A couple more points on that. There's, I think, a little bit of confusion also about the issue regarding whether or not people can have needles and medications at private farms. The prohibition on needles and medications only applies to racetracks and official training facilities. So that does not apply to a private farm. So there's no issue with you keeping your medications and whatever else you think you need for emergency situations for your horses in private farms or private facilities. I'll answer any other questions that you might have on that rule, but I just want to make clear that one, it's been narrowed, and that will be, the FTC has assured us they'll be approved by July 1. And if for some reason it isn't, we will act in accordance with the modification. Two, we have no intention of looking at people's private property, or that's not what our mission is, nor what our interest is. And three, the needle and medication issue doesn't apply to private farms. The second thing I want to clear up from the outset is that there was some confusion that probably I need to take some responsibility for, because the rule wasn't entirely clear around the voided claim rule. And I want to make sure that it's really clear and everyone understands the implications of it. If in fact there is a horse that's claimed, the records that have to be transferred from the trainer are only the veterinary records and treatment records, so that the horse can be properly cared for by the new owner or new trainer. You don't have to transfer your training records or your sort of special whatever techniques or approach you use to training your horses. That is not something that needs to be transferred. It's only the veterinary records and the treatment records. So I think with those two issues, I'm going to open up for questions. And if anybody has anything they want to know more specifically about those rules, I'm happy to answer them. But I thought it'd be helpful to just start with, an overview on those two rules.
Good morning. Let me just step in for 1 second. I want to follow up with Lisa. For those of you who don't know me, I'm the MTHH General Counsel, Alan Foreman, and you've probably seen and heard a lot of me in the last few weeks. I don't work for HISA. I'm not the face of HISA. Our responsibility at MTHA and with all of the horsemen's organizations, both here, regionally and nationally, is to make you all aware of the requirements of HISA and to make sure that you comply and that the transition to this new regime is as smooth and painless as possible. We all know this is a big change, and change is not easy. There is a great column that I invite you all to read this morning that Ray Pollock wrote, comparing what's happening here now to the implementation of Obamacare. And maybe, healthcare and horse racing don't go hand in hand, but this country was very much divided over a new healthcare system that some wanted, some didn't want. The states wanted to retain control. The federal government wanted to assume control for the best interests of our healthcare. It was painful. There was lots of litigation. That litigation continued, but it happened, and it happened on the implementation date. And we now have it. It's part of our daily lives. And I think a lot of people like it more than what they like the previous system was, although I'm sure there are plenty of people who don't like Obamacare. But the fact of the matter is, and I think that it's something that needs to be emphasized, This is the Horse Racing Integrity and Safety Act, 66 pages long. And this is what is going to guide our industry completely in the areas of anti-doping, drug testing, and the safety, health, and welfare of our horses and riders. And much of what is in here is what we are already doing in Maryland, and we are doing in the Mid-Atlantic. There are some changes. There will be some changes. But the fact of the matter is, and we've been saying this to you for how many years now, that if you buy into the system that is coming into racing and you adhere to it, this will not be a heavy lift. And I continue to maintain that, and I stand by that. And the role of Lisa and Ann and HISA is to take this act and create regulations that are consistent with the act. They are a private independent entity. They are not the federal government. They are overseen by the Federal Trade Commission, and everything they do is being overseen by and must be approved by the Federal Trade Commission. And the Federal Trade Commission has said, whatever you do has to be consistent with this statute. They can't go outside it. They can't go beyond it. They have to be consistent with it, so that everything you see and everything they do, and the rules, quite frankly, and regulations that are being prepared are being worked on with industry experts. And all of us, your horsemen's groups, individuals, have the ability to read them, comment on them, talk to HISA. But at the end of the day, there is a decision that's made, just like a racing commission makes a decision. A rule is proposed. We comment on the rule. We try to massage the rule if necessary, and then the rule becomes law. And on July 1, unless a court steps in and joins this process, and there have been 2 lawsuits filed in 2 federal jurisdictions so far, and injunctions have been denied in both of those jurisdictions, this act is going to take place on July 1, and it is going to be the law as it relates to medication and the health, safety, and welfare of our horses and drug testing. And HISA will step into the shoes of our racing commissions in regards to those 2 programs. I'm going to turn it back to everyone, but I want to comment about search and seizure because 90% of the questions have come about search and seizure. This is the current Maryland Racing Commission application. It's consistent with the license applications in just about every jurisdiction. And in that application, you sign a waiver of your rights to search and seizure for any property, including vehicles and yourself, on the grounds under the jurisdiction of a racing commission. Now, there are some states, a few, Kentucky, for example, that go beyond that and give the racing commission much broader power. But the fact of the matter is, what HISA needs to do is to ensure that there is jurisdiction over all covered horses, all covered individuals, which are all of you. And so there is a search and seizure provision, not different than this one, with 2 exceptions, okay? The first exception is, and this was feedback that we got from most of you, horses that are stabled at Fair Hill currently are not under the jurisdiction of any racing commission. There are timed workouts being done. There is training being done, but you're subject to a different standard here than the horsemen at Fair Hill. And it isn't just Fair Hill, it's at any licensed training facility around the country. So HISA now has incorporated those training facilities into the law. So horses that are training and horsemen who are at Fair Hill or any other licensed training facility in the United States where there is a timed workout being conducted are subject to these requirements, okay? And if you have a farm where you train horses and timed workouts are allowed at that farm, then HISA does have jurisdiction if they want to. Now, what are they going to do? Most of the complaints we seem to be getting are from owners who are concerned that the search and seizure requirement allows HISA to go in to their offices. Like, I'm a lawyer, they come into my office and barge through my files looking for something, I guess, related to horse racing that they would find could infer a violation of the rules. And that's not what's intended here, okay? They are going to have the right when you're on racetrack property. But if I'm an owner, for example, the Racing Commission right now by subpoena can order me to turn over records. They can order an investigation. It's just not so clearly spelled out, but it's clearly permitted under Maryland law. And what I believe HISA will do is, with respect to an owner, please, and they need to get information, please provide us with whatever records you have from your trainer. Please provide us with your veterinary records. Please provide us with your billing records. And the owner can say yes, he can say no, and then HISA can pursue it. What, are they going to come knocking on your door and start rifling through files? No, that's nonsense. And those who are putting out that information are just trying to stir the pot. Okay, so it is, it's not terribly different, quite frankly, than what is the case now. And what we're going to be doing going forward with everything involving HISA is comparing what HISA wants us to do compared to what we're currently doing now, so that you can see the differences and understand the differences. The biggest difference will be, and we won't even get into that today, is when we finish the anti-doping program, is understanding how the disciplinary system will work, because that will be different. The only thing I want to say about medication, I'm going to turn it back to everyone because we are just starting to go through the medication rules, but we're finally going to accomplish something that we've been trying for years to do in this industry, no matter how we try to do it without success. And that is, for the first time, we're going to be able to divide doping from therapeutic treatment of horses for the best interest, the safety and welfare of the horse. We are finally going to, in the public's eye and in the industry's eyes, be able to break those apart. And we think that's going to be a huge benefit for the industry, for all of us, and for the future of the industry. So I wanted to clear those things up. I'm going to turn it back to
comment on this.
Dale, you need to speak. You need a mic.
When I read these rules and regulations, I consider them to be absolute. Because I haven't found where it says intention. So if the intention is not to do this and do that, why can't those rules be changed so they're taken out? Because I cannot find a spot that says the intention is not there.
When you say intent, what would you take out of the rule that you don't like?
Well, which Lisa talked about was search and seizure. Very simple. The intent, she said, is not to do that, but they can do that. Under the rules now, wait, that's on the grounds. That's on, if you come into the track, we all know that they have the right to search your vehicle and all that stuff. But if they'd have to get a subpoena to come to your farm to search it. And I'm all for, I've been about the training centers and Fair Hill and every other place don't have to play by the same rule as we do. You know how I feel about that, and I've been strong about that. But on the other hand, I do not believe that we can trust the federal government on very many things to not have the intent when they can do it to go after it. It seemed to me when I read through a lot of this stuff, when you check accept, you give up a lot of your rights. So that's why I have exception of what you're saying about intent. If I'm wrong, tell me I'm wrong.
Well, Lisa, do you want to handle that? Or I mean, I'd be happy to handle it.
No, I mean, I'm sure I'm happy to answer. And then if you want to add anything, Alan, please feel free. So a couple of things. One is we have actually already modified the rule to make it more narrow. So I don't know if you're looking at the old version or the new version, but the new version does specifically attach only to a covered horse race, a covered horse, etc. So that is more narrow. And second is, I don't have one thing. I think Alan, I appreciate him, saying it at the outset that I didn't say is that I didn't write the law. We didn't pass the law. I don't have the authority to change the act itself. That's the power Congress wants us to have. And we have voluntarily narrowed that power to show our intent because there was so much concern. Beyond that, I can't do any more. And you'll just have to, and I guess the other thing is that we're not the federal government, but as Alan pointed out, almost every single state has a similar rule. Many states actually have a broader rule, not Maryland, but a number of states have a broader rule, like Kentucky, Louisiana, Indiana, than what HISA has. And you know, we have a lot of really important priorities, and going to people's businesses, et cetera, are not a priority for us. Our priority is to protect horses and people, and we'll only use that right if we think there's a compelling reason to achieve our mission. And I really can't offer, I don't think, any more than that at this stage.
Well, that's what I expected you to say. So what most of us are here complaining about is a rule like that is incumbent upon you to enforce it if you think you need to, and you say that you won't. So we would just ask, and we've been asking for a delay in implementation until you can clarify all of these rules, because there's umpteen zillion of them in there that are unclear. And I'm glad you said you have a lot of time, because as you know, we sent emails back and forth. I've got a litany of questions that will take a lot of time probably for you to answer. And again, you're basically skirting around my question.
Listen, I don't think I'm skirting around your question. I understand that, like, there's frustration, there's anxiety. We're just going to have to let the rules take effect and see how they're enforced. You know, as I said, we volunteer. I don't think you're looking at the most current version of the rule. We voluntarily narrowed it. And you know,
for me when you say I'm not looking at the newest version of the rule, because they keep changing. So we don't know.
Dale, they're going to keep changing, just like rules change in the racing industry.
Exactly.
They did make a clarification at our request to narrow the search and seizure to covered horses, covered races, and information related to the care, training, and health and welfare of the horse. Doesn't get much narrower than that.
Well, then again,
They're not going to build in what you want, which is, we don't intend to do this. We don't intend to do that. What I think Lisa did say is that if there is a situation where there is a need for us to go in, we will do that. And we think it'll be a situation that you would applaud us for doing it. Are they going to do it on a routine, regular basis? The answer is no. The Racing Commission has the right to do that here every day. And how often do they exercise that? How often do they go into your shed room? How often do they go into your vehicles? Okay.
Alan, former
Alan,
Congressman and Tom Rooney wants to chime in. He's on Zoom here. Tom, you want to go ahead?
Yeah, I hope y'all can hear me. I'm on 95 in Virginia, so I'm sure you can all relate with my state of mind. But anyway, as somebody who taught constitutional law at West Point, I can assure you that there is no law that is written that overrules the Constitution of the United States. You have the Fourth Amendment right to be protected against the government searching your persons, places, papers, and effects without, unless they have a subpoena based on probable cause in a court of law. All the HISA bill allows for Lisa and HISA to do is, if you are, as Alan just said, a license holder for racing. A license is a right, is a privilege that you are given to race in the state of Maryland or wherever. It's not a constitutional right. So if you want a license to race, you avail yourselves to the rules of racing. And one of those rules says that in this case, HISA can come to the barn if there is, you know, a reason to do so, but it does not overrule your constitutional rights. If you demand a subpoena, then at your house or something like that, that is still your right under our Constitution. So I think that everybody needs to understand the difference between the Constitution, a law, and a license privilege that we all pay for. Also, somebody asked about who wrote the law. The law was written by Representatives Barr and Representatives Tonko. So this bill has been under various iterations over the years. So when Lisa talks about the latest iteration, there's been many iterations of this bill before it finally became law last year. So I don't know if that clears things up for everybody, but the federal government cannot come to your door in violation of the 14th Amendment or Fourth Amendment, period.
I have a question. So the search and seizure in the discretion of the new authority. You know, what I'm concerned with is the lack of discernment, you know, the experience. So recently I had a contamination positive, which if circumstances hadn't have prevailed, that would have been anchored on my back, right? So I have a contamination positive for meth, right? To the non-discerning eye, how does that look? Because you say in extreme cases, right? So new people coming in, looking at that, and without the added information of finding the culprit, right? That's on me. And then remember, Alan, when I asked you, so if that happens to me a second time, what goes on from there? And you said, then you get a 6-month ban, right?
Well,
So that's kind of how dogmatic, you know, these laws are. There's no wiggle room for, you know, discretion, discernment. There's nothing judicious about them. So put them in the hands of someone who's pretty ignorant to the game, have not had the experience. And how does that play? I end up looking like a criminal.
So we're not going to talk about medication today, Hugh, but I would tell you that just based upon the work that's being done right now, I would disagree with your characterization, because there will be an opportunity in cases such as yours to differentiate between intentional and contamination. There will be the opportunity to determine fault or no fault. So it's not going to be terribly different than what happened with you in that particular case. And penalties and everything else will be clearly spelled out. But from a search and seizure standpoint, with your positive test, the Racing Commission, if it were to happen today, would come into your shed row, correct? They'd conduct a search, they'd interview, they would seek to find the cause, and it's not going to be any different here.
Yeah, just to add on to that, I know we're not talking about it, but certainly contamination cases are considered within the rules in 2 ways. One is if you can show it's contamination, it's no fault, so it's like it never happened. And the second is that there are certain substances that are more prone to contamination that are called specified substances that potentially result in even a lesser penalty. Those substances that if they're actually intentionally used would be prohibited, but we actually allow for sort of more intense scrutiny of those substances that are more commonly found as contaminants. So that is an issue that is very well addressed in the rules, and you can look at them and provide feedback ahead of their implementation on January 1.
And let me just say, we will have a separate webinar meeting similar to this when we get to the medication rules, which are still being developed. So there's no reason to draw any conclusions right now with regards to medication. The program that goes into effect, excuse me, the regulations that go into effect on July 1 are the safety program, the registration requirements. You will have not only ample notice, but ample opportunity to comment on the medication rules.
Yeah, I'm not saying this is related to the medication thing. What I'm saying is the nature of the investigation will, if it's a meth positive and it's on my back, they have the authority to go to my home and just pretty much go through my stuff. Right?
I don't think that's the case.
in the, that's
I would disagree with that. Okay, I would disagree with that.
on
Right. I would advise you not to let them in. I would advise you not to let them in and tell them that if there is a need to go into your home, get a subpoena. Okay? And that's no different than the way the world works today. And I will tell you, in situations like that, we'll have your back. Okay? Well, okay. If, you know what, Wendy, if you don't want us to have your back, that's fine.
We want to answer some of the questions from the chat, because I know there's a lot of questions in the chat.
All right, well, for those of you in the back, we're trying to do a webinar that everyone who is participating via Zoom can hear. They cannot hear you. Our moderators can't hear you. So let's hold those off to another time. Okay, let's get to the questions, please.
So my question is like kind of what he referred to right now under the uniform or for the Mid-Atlantic, next to certain substances, it'll say mitigating circumstances. There's like a guideline. And I think that's what Hugh is referring to, like mitigating circumstances. So under this HISA Act, the trainer is going to bear all responsibility regardless of the situation, which puts you in a very, I mean, we are feeling like we're being backed into a corner.
Do you know what the current rule in racing is with respect to trainer liability?
Well, I understand that we're the ultimate insurer, but what
Strict
Hugh's
liability.
referring to
Different.
in that column on the right-hand corner where it'll say like your sentencing guideline, your first offense, it's a $1,500 fine, no days for something like Butte or something like that. Everyone's concerned under this act, you're going to lose all mitigating
No,
circumstances.
you're not.
And, you know, like, are the stewards not going to have any say over what happens to us anymore?
Look, there's no point in dealing with medication today because we don't have regulations to comment on. Okay, we have drafts that we're providing comment to HISA so that they can formalize what it is they want to do. Okay, but there will be provisions for mitigating circumstances. There will be provisions for resolving cases administratively without a hearing. There will be a hearing procedure that is very detailed. There will be appeal rights that are very detailed. Okay, those cases will not be determined by your stewards here. Okay, there will be a different group and it will be uniform around the United States, and every horseman across the country will be treated the same. It won't be that it's one way in Pennsylvania, one way in Maryland, one way in Florida, one way in California. It will be the same for everyone.
And is it going to be that way for the jockey whip rule? Who's going
Same
to?
thing for the jockey whip rule. The whole point of HISA is to create national standards for everyone to meet and abide by. Okay, whether you think that we're a state sanctioned, state controlled business, yeah, 4 decades, 5 decades ago, we were, but the world's changed. And there is an expectation in the general public, in the media, and even among a large segment of our industry that we need to be uniform, that everybody has to be treated the same. And it's going to give us the opportunity when we run into situations like Santa Anita or Service in Navarro or whatever it is, to be able to explain that we have standards that we expect everyone to follow. And when people don't follow those standards, we sanction them for it. And everybody's going to be treated the same.
I can just add one thing. I feel like I just want to say that it sounds like some of the questions, the last questioner was asking, show that maybe she has not seen the most recent version of the rules because they seem to reflect a misunderstanding of what's currently in draft form. So I would encourage you to look at the rules, read the rules, speak with Alan, because we're taking comments now and we're listening. And those rules, as Alan said, are only in draft form.
So everything is on HISA's website. Plus, there are a number of publications and websites across the country that are currently publishing. It's been widely announced. What is HISA's draft medication anti-doping program, drug testing program, arbitration procedures. They are an invitation to the industry to see what their thinking is and to provide comment before they seek to formalize regulations that we can formally comment on. And a number of groups and number of individuals have already begun meeting to look at it and provide comment. Each one of you who can get on the internet can go to HISA's website and can see these regulations. You can ask questions. You can submit them to the MTHA. You can submit them to me. You can submit them to David. You can submit them to Lisa. They will get answered. And I can assure you that when the medication program goes into effect on January 1, 2023. Can you hear me? January 1, you will be well familiar with what the requirements are. And you will have a much better understanding. And I just think it's probably not helpful today to talk about it because we don't want misinformation to be floating around. But we invite you to look at those regulations and comment.
And this is what we're, as a bunch of horsemen, and I take a lot of input from, but that's what we're asking for. We want all of your regulations put in place by January 1st, but you're asking us to sign something by July 1st that we're agreeing to, you're not even having the rules in place. So all we're asking is.
Can I address that, Alan?
We want you to get your rules and regulations in place. Okay, January 1st, we all have to get a license. If we want to sign it, we don't get licensed. But get it in, you can't make us sign something that we don't know what we're signing. We have no idea what we're signing into. And I've been doing this for 40 years. And just 2 months ago, I had 2 Butte positives. Nobody wanted to hear about contamination of the rats, but that's what it was. And this is not sanitary. I mean, it's just not sanitary enough that we're going to get 6 months or whatever it's going to be. We haven't decided for Butte positive, something we use every day in the thoroughbred industry. Please put it all in writing. Please
So first,
put it all in writing.
if I can just address it. So first of all, Butte positives don't come into effect until January 1, and there's absolutely there's no 6-month sanction for a Butte positive. Again, I feel like a lot of the questions here show that the rules have not been read. You should read them, provide comments, but they're up for public comment. We have absolutely no authority to extend the racetrack safety program beyond July 1. This is congressionally mandated, and we have no ability to delay that date. But the rules that come into effect on July 1 are much narrower than the medication rules. And that's why we're here to answer any questions about them. And we've been conducting a lot of outreach to make sure everyone knows what they need to know on time. The other point I want to make is about the signing up to accept our rules. One, the registration process is a way for us to keep track of the program, communicate with all of you, and it's an eligibility criteria. But the federal law applies to you whether or not you register for HISA. I mean, it's a federal law. It's been passed by Congress. There's nothing to do with registration. A registration is the way that we can check your eligibility and we can actually run the program. However, if you decide that once the medication rules come into effect January 1, that you want to unregister, you can unregister anytime that you want. Unregistering is something that we are happy to do for anybody who wants to, at some point in time, not be eligible to run in covered horse races. When you sign up, you don't sign up for all of time. You have the ability to unregister whenever you want.
Let me I just want to add one thing. There is I saw this yesterday. There's a letter floating around asking people to contact. Is that working now? Okay. There's a draft letter floating around. I saw it yesterday, encouraging people to sign the letter and send it to their congressman, asking them to seek to delay the implementation of HISA. It would take an act of Congress before July 1 for that to happen. And you tell me what you think the likelihood of that is. This bill was sponsored by Mitch McConnell, who controls the Republican caucus. It had the support of Senator Schumer, the majority leader, and the Democratic caucus. So even if Congress wanted to, it's not going to happen, number one. Number two, the decision on adjusting effective dates and the like rests with the Federal Trade Commission, not HISA. And the Federal Trade Commission has agreed to certain delays with respect to the medication program. The third-party vendor was not in place because of the negotiations with the United States Anti-Doping Agency, the shoeing rule for supply chain issues, and now the whip rule solely for supply chain issues. But there are no other circumstances, I don't believe, and I'll stand corrected by Lisa, where the Federal Trade Commission has indicated a willingness to delay anything.
Lisa, is that correct? What Alan
Yes,
just
that
stated?
is correct.
That is correct.
That is correct. That is absolutely correct.
And so basically what you just said is if the anti-doping had been set up, the testing, because that's what basically set you back, correct?
no,
Did you-
what?
You didn't get the
what said
testing.
it- No, well, I'm not trying to understand your question, but I'll answer it to the best of my ability. The act requires HISA to enter into an agreement with an enforcement agency before they can implement the anti-doping rules. And that was not the, USADA was the agency that HISA was initially negotiating with. They were unable to reach a deal with USADA. And so once those negotiations terminated, we then negotiated with the Center for Drug-Free Sport, and that appointment didn't happen until May. And so we needed obviously that additional time to present the rules and to have them approved by the FTC, because we could only present them once we had an enforcement agency in place.
That makes perfectly sense. So what you're telling me, if that had happened, it would have started July 1st.
If USADA, if the HISA had entered into agreement with USADA, yes.
Yeah, it would have started July 1st with all your rules and regulations on medication incomplete on June 16th. They're incomplete now. Your rules and regulation, as Alan said, you're still going forward with it. If you'd have had that anti-doping agency in place, you'd have started testing with incomplete rules. So basically, yes, Alan,
No.
that's what you just said.
That's not, Dale.
If
If,
these things
if,
issues.
if HISA had entered into an agreement with the
Exactly.
United States Anti-Doping Agency, let's say they entered into the agreement in January, February, then we would have been able to go through proposed regulations. USADA had posted.
What difference does it make whether you got that regular?
Because there would have been time requirements to get them done. You wouldn't have been dealing with incomplete
Well,
regulations.
how come they're not done now? I mean, just like
Because-
Johnny Salzman said,
Because it was suspended.
everything
until they-
stopped. You didn't know that these rules and regulations needed to be adopted.
The
and needed to be
anti-doping-
massaged. Everything stopped because you had no testing laboratory?
It's got nothing to do with testing
Then why did
laboratories.
it
It ha-
stop? That's why I'm asking. you. I don't understand.
Gail, you're not asking the question. Here's the answer to what I think your question is. And that is that with the approval of the Federal Trade Commission, the anti-doping program, which should have gone into effect on July 1, will go into effect on January 1, which afforded HISA and the industry sufficient additional time to, number one, for HISA to negotiate and enter into an agreement with a third-party enforcement agency, and to create the rules and regulations for protocols for medication, drug testing accreditation requirements, arbitration, and the like, which is now being done in anticipation of a January 1 startup date. Had HISA entered into an agreement with the United States Anti-Doping Agency in a more timely fashion, and because they couldn't, but if they had, those regulations would have gone through the very process we're going through now, would have been ready, and would have gone into effect on July 1. But because of the delay, that was put to the side in order to get other things ready, because the statute requires that this program start on July 1, which is what's going to happen.
Again, I think you're missing my point, Alan. You sure about that? Because it seems to be clear to me that if you'd have had that agency in place, you'd have had all these rules and regulations up to par, which they're not now. And we'd have been agreeing. Makes a big difference.
Training under the existing Maryland Racing Commission rules until January 1, 2023. January 1, 2023, you will know what the new rules are. You will be familiar with them. And if you want to register, if you want to be a covered person, and you want to participate, you will be required to adhere to it. So it doesn't matter.
Well, it actually does matter. And I mean, everybody in this room wants the same thing. We want uniform medication rules. We want safe racetracks. We want the cheaters thrown out. Everybody in here is in agreement with that, I'm sure. So here's the problem I have with the whole thing. You wouldn't have to twist our arms and force the racetracks to no simulcast signal unless they agree. And you wouldn't force owners and trainers to sign up for it by July 1st. We would all be jumping on board because that is what we want. So being forced to do it, you can tell something's not right. But let me just go to this civil actions. rule here because it's quite intrusive on everybody's rights. It's civil actions in general, rule number 1. It says, in addition to civil sanctions, which we talked about, right? That's when you have a positive test for anything. I'm reading from the HISA stuff. I don't know. Rules and violations, section 8 is what we're going to refer to. So I didn't get the copy. It came from govinfo.gov. So this is the HISA rules. Okay.
Is that what USADA published or is that what HISA published?
I think he's talking about the act itself.
Did not
I'm
enter
talking
into-
about the act itself. Yes, ma'am. I'm talking
Yeah.
about the act itself. Okay.
Yeah.
So it says, in addition to civil sanctions imposed under section 8, which you have to go to section 8. And if you're familiar with section 8, you might not be. Lisa, you probably are, because this is where it comes in. Section 8, rule violations and civil sanctions. Okay. Rule number 2, the presence of a permitted substance in a sample in excess of the amount by the horse racing and doping and medication control program, and the use of permitted method in violation of the applicable limitations established under the horse racing and anti-doping medication control program. If you have a positive, the way that I understand that, then we got to go back to civil actions in general number 1. It says the authority may commence a civil action against a covered person or racetrack that has engaged, is engaged, or is about to engage in the acts of practices constituting a violation of this act or any rule established under the act. Which further goes on to say, in the proper court of the United States District Court of the District of Columbia, or the United States Court of any territory is subject to jurisdiction of the United States, to which enjoin such acts or practices to enforce any civil sanctions imposed under that action, or for all other relief to which the authority may be entitled.
So
What does that mean to you?
what it means to me, under current Maryland law, if you are reported to have a positive test, okay, you have a hearing, a penalty is issued. All right, let's assume you get a 15-day suspension and $1,000 fine. That's a civil sanction. Exactly what's provided for in the act. Okay, if you want to take an appeal, you can take an appeal from the stewards to the Maryland Racing Commission. If you're not happy with that, you can go to the circuit court. You can go all the way up to the Maryland Court of Appeals if you want. Under this, you will go through their disciplinary procedure, which could be, and it is not finalized yet, but it could be an administrative sanction. You voluntarily agree with the authority to a fine and a suspension. That's a civil sanction. You could ask for a hearing. You will go to a steward or a steward panel. From there, you can go to an arbitration panel. There, you have the right to appeal to the Federal Trade Commission. And if you're not happy with the Federal Trade Commission's decision, you can go to a federal court that now has jurisdiction. It's a different lineup of where you go through the process, but it's all civil sanction, whatever that sanction is.
So this doesn't mean that the authority,
Am I correctly so on that?
the authority can come after you
Yes.
if
I'm
they
correct,
want to
correct.
investigate you more and pursue it more. That's how I understand it. I know what my rights are. I understand that completely what you said.
If the
That's why I'm
authority,
asking.
I shouldn't answer. If the authority of the investigators feel that there is a reason to conduct a further investigation, they will have the authority to do so. But that's no different than what the Racing Commission here currently has. Whether they've exercised it or not, there is nothing different about what they will do than what an existing Racing Commission could do.
That's not really what it says. I mean, you're telling me, Alan, that I go by what I read in black and white. I don't go by intent. Because when I get in trouble, I say, well, I didn't intend to do that. It just happened. I mean, that's why I want clarification, because I think most of the horsemen here don't understand that they could be fighting a lawsuit. Am I wrong, Lisa? That
You're 100% wrong. You're 100% wrong, 110% wrong. There is no lawsuit. A civil action is the anti-doping procedures. They're the disciplinary procedures that will take place if your horse tests positive or if you use a prohibited substance. There is no civil action. The civil action is the anti-doping procedure. Nobody's suing anybody. So you're wrong.
So I'm wrong. No one has to worry. Well, that makes me feel better. That's why we're here, Lisa, to get
Good.
clarification, right?
Okay.
On these things that come up. So that makes me feel a bit better. That's why I said I'm glad you have all day, because I got a litany of other stuff here, but I'll let somebody else speak.
Well, I'm sure there are others who have questions. Let's try to get as many answers to questions as we can from others.
This is a real softball question. It has to do with registration of the horses. We have a lot of layup horses on our farm for various trainers. They have all indicated they will only be registering horses under their current custody and care at the racetrack or at a racing facility. Does the owner have to register that horse, or I, as the owner of the farm, can I register the horse on their behalf? And do they have to be registered by, they've all either raced or had a timed workout? One of the horses, a 2-year-old, had a splint pin fired. What process do I need to go through for the registration of the horses, which is about a dozen of them, for various trainers? And none of them will be back to the racetrack before July 1st.
Lisa, would you like me to answer that, or would you like to take that?
You can go ahead, Ann, no problem.
So if any horses are ready, first of all, my name's Ann McGovern. Thank you so much for letting us come and talk to you. And I am so excited now to talk about the rules, which go into effect, and get off of some of the items that really don't affect us right away. But as far as registration goes, your horses that have had a timed work can be registered at any time now. They need to be registered prior to any entry date. If they're going to be running in the near future, they need to get registered now. If you have any horses that you're running right now, besides those, you as a trainer need to be registered, as does your owner. Now, I'm going to give you a tip as a trainer. When you go in to register the horse, it will ask you for the owner's name. If the owner has not registered yet, your name will default into that spot, and you'll continue registering the horse. Once the owner registers, you will have to go back and put the owner's name in. So my tip for trainers out there that have several owners, get your owners registered first, then go in and register your horses, and it will automatically populate with the owner's name. So to answer your question, hopefully a little more directly, your horse needs to be registered before it enters any race. They are eligible to be registered at any time. If they're not going to race for 6 months, you can register them now and get it done with. But they do need to be registered prior to entry.
Well, just for your information, when I called the HISA office, the person that answered the phone said all the horses have to be registered by July 1st. So what you're telling me, the horses on my farm do not need to be registered by July 1st. They can be registered when they come back to the existing trainer. Is that correct?
Yeah, that is correct. But they can be registered before then. I believe the person on the phone was probably assuming that you're going to be racing in the near future, and was
I
trying to.
indicated they would not be. I said these horses won't be back to the racetrack for months.
They are still covered horses and should be registered as soon as you can, but they will not be allowed to enter until they're registered.
Okay.
We'll change the
Like I
training
said, I
on
don't need
that.
to worry about it. I can send them back to the trainer October 1st. They're not registered, but the trainer can register then on October 1st, and we're okay.
Yes,
Yeah,
Is that
100%.
correct?
that is correct.
Okay.
Yeah, we're sorry about that. I'll change the training that we have for the people answering the phones there to make sure that they clearly give you the answer, as opposed to just give you the answer what you got. So my apologies for that.
Okay, the other question that I would have is on the pin fired horse. Okay, it was pin fired. I can't even remember when, exactly. It was only a 2-year-old. So probably in January or February this year was a splint. You have to indicate that the splint, is there. When do I do that? Obviously it was, before July 1st of this year.
So HISA's rules are not, do not go backwards. They begin July 1st. So when you register the horse, you're not required to put past medical history in the horse's files. However, we would encourage you to do that so that there is a history for you or next owner to look at, but you are not required to put any medical records in prior to July 1st.
And the only thing I would say on the pin firing is if you could just, maybe take a photo before July 1st or just have some record in case the veterinarian, the regulatory veterinarian at your, whatever track you're at, asks you about it, they're all going to be trained to know that, obviously this only goes beyond, July 1st and beyond, and they're expecting there's going to be, obviously people have used that practice before. But just to protect yourself, and just to be able to communicate properly.
Oh, we've
you
already
just
done
need to
that.
have a record.
The other
Okay, then you're
question-
good. Then you're fine.
The other question I would have on the 2-year-olds, it is common practice that the 2-year-old, or the horses that are in the 2-year-old training sales, somewhere in January, February, they scrape shins. Is that going to be prohibited?
If it has a blistering, I'm looking at the rules, and if it has a blistering effect, and I'm not familiar with the technique of scraping shins, if it's a thermocautery or cause a blistering effect on a shin, then it's prohibited. So I would have to talk to the vets on our committee for me to understand exactly what scraping shins is. So I'm not sure I can completely answer that, but once I know exactly what that process is.
They inject a needle in the shin, they scrape the shin, they inject a hypodermic needle in, and they scrape the shins.
Okay. The
Right.
rule regarding pin firing and freezing has to do with thermocautery, so I'm not sure an injection would fall under that, but I'm not aware of it, but I would have to check on that, and I'm happy to
Okay,
do that.
so the bottom line would be, at this stage in their life, they have not started, they are not a covered horse, so you would still be allowed to do that. Is that true or not true? Yes, no?
Our rules don't apply until they're a covered horse.
Okay. And about the pin firing, can you pin fire, or is that prohibited now for a 2-year-old or through whatever?
From July 1, you can't pin fire any covered horse.
Okay, so basically a 2-year-old that has not raced, he's not necessarily be a covered horse, he could be pin fired.
I mean, go ahead, Alan. That's the unfortunate
A
consequence. of the
covered
rule.
horse is a horse that is 2 years old and has had its first official timed workout.
Exactly.
Okay, not that he's raced. So at any time prior to that, there is no prohibition.
Correct.
Once that horse turns 2 and has had an official timed workout, that horse becomes a covered person and you cannot do it.
That now or July 1st?
July 1st.
All right, we got another question from the
And-
back.
HISA does not go, as Ann said, HISA does not go back. Okay, this is going forward, not going backwards.
All right, we got a question from the back here.
Yeah, I have a quick question. One is, if you appeal, are you automatically ruled off and suspended? Or if you have an appeal with HISA, with the federal government, over anything, whether it be drug testing or whip, are you able to continue doing it until your appeal is heard? Or are you off until they get to you, to your
Okay, so-
appeal?
Let me answer that question. So first of all, it's not the federal government. I just want to make that clear. We're not the federal government. We're subject to FTC oversight, but we're a private entity. 2, again, the anti-doping rules are still up for public comment, so they're not finalized. But essentially, because the new draft, assuming the new draft is ultimately more or less what gets finalized and confirmed and approved by the FTC, then the substances are split into 2 categories. One is banned substances, which are doping, and the other is therapeutics, controlled medications. The only time you'd have a provisional suspension, which would mean that you couldn't compete or participate in training in racing until there was a resolution of your case, is if you fall into the banned substance category. And that category are those substances that should never be in a horse. They're not the therapeutics, they're not the buttes, et cetera, that you're allowed to use between races. Again, those rules are not finalized yet, but that's what the current version says.
Okay, and the second question is, when will these fees, you have your drug testing fees and you're going to have your HISA administration fees. Do they go in effect July 1st or January 1st?
So the original fees, the assessments for 2022, which covers the period July 1 to December 31, has been allocated to the states. And the MTHA, the Stronach Group, and the stakeholders have all agreed on covering those payments. So you will not individually be billed for any of those payments. In the fall, when the anti-doping program has been developed, HISA has the responsibility under the statute to develop its budget for the next succeeding year, to publish that budget and allow for comment before it's approved by the Federal Trade Commission. HISA's current position is, but this could change, is that they are not going to mandate how that money is spread among the stakeholders in each state. In the first instance, the statute empowers the racing commission in a state to make that determination. If the racing commission decides not to do it, then HISA has given that authority to the racetracks working with the stakeholders to come up with the formula that will fairly and equitably spread those costs among all the stakeholders in that state. And that has to be reported to HISA, so that if there is a formula that appears to be either not equitable or unfair, HISA can step in and correct it. If the tracks refuse to do it and the industry stakeholders refuse to do it, then HISA has the ultimate authority to make that determination and to bill the stakeholders accordingly. So the answer as of right now for the remainder of 2022 is that the stakeholders in Maryland have covered those costs. You will not individually see any bill for that, and life goes on.
The year, depending on
we
what
are-
they instigate.
Well, it's going to change for two reasons. Number one, the current budget doesn't include the anti-doping program and the cost of the anti-doping program. And we will work with HISA on how we can best allocate those costs and minimize those costs. Number two, we're continuing to have discussions with HISA on how they create the formula.
Okay.
Okay, the formula could change. So a lot of moving parts, but by law, they are required, I think the date's November 1, but I could be wrong, to have the budget in place for 2023. And that number will be, obviously, it'll be different than it was for 2022. And we not only have, we're working on how to best do this in Maryland, but we're working with all our fellow horsemen's groups in the region to make sure we're all trying to do it in a similar fashion. And we're working with a lot of groups nationally that are looking for the same thing.
Maybe one thing I want to add to that, if you don't mind, Alan, is that once we get into discussing the anti-doping program, there are a number of processes and costs that HISA is going to assume that were originally state costs. And we are hoping that we're going to be able to access state budget in order to, reach agreements with the states in order to access some of the existing monies that are there in order to make sure that we have the greatest efficiencies. So we're going to do everything we can, obviously, to minimize those costs and minimize the effect on participants.
It's a question all the way in the back.
Hi.
Good.
Is it on? Yeah,
Yep.
okay. Back to registration, sorry. But I got a little overly rambunctious, so as an owner, I registered my horses under my profile. But I am not able to now move them off of my profile and put them under the trainer profile. I've called several times and held and was promised to call back from HISA, which I have not received a call back yet. But once they're entered under that profile, they can't be removed and then entered under the trainer. They have to be able to.
Yeah, it's not that they get removed. They actually you actually transfer the responsibility to the trainer. So on the horse detail screen, you will see a button that says to transfer to trainer.
I tried that.
And that trainer will then get a message to accept the responsibility for that horse.
Okay, I did try that. And
So
the trainer's my
the-
husband, so, and I have access to, of course, his profile, and he does not have a message.
All right. Can I send you an email and we can get on a web
Yes,
screen so that I can take a look at why it's not working for you?
okay,
So I'll facilitate that after the meeting. So
Thank you very much.
thank you.
Why is there a loss of owner's purse surrounding the jockey whip rules?
The idea behind the jockey whip rules was to take some of the pressure off of jockeys. And let me just review them really quickly. There's 3 classifications of violations within the crop rule. And if there's a class 1, a class 2, and a class 3. If a jockey receives a class 3 violation, that would be 1 to 3 strikes over the allowed 6 strikes. A class 3 violation does not disqualify the horse or doesn't result in a loss of purse. When a jockey violates the crop use more than 4 times, that's when a disqualification of the horse and a redistribution of purse occurs. And the feedback we had from jockeys when these rules went out for public comment and for jockey comment was there are times that jockeys, I'm sure no one in the room falls under this category, but some trainers, some owners will pressure a jockey to do what they need to do to win a race, and that the owner or trainer may pay the fine the jockey ends up receiving for that. So and jockeys, don't want to lose the opportunity to ride for an owner or trainer and are caught between a rock and a hard place. So when we were looking at penalties for the higher number of strikes, we felt this would give it an opportunity for the owners and the trainers to be discouraged from that practice and take the pressure off of the jockeys.
Yeah, if I could just add one thing to that. We spent a lot of time in the Mid-Atlantic Strategic Plan meetings looking at the whip rule because there were many factions in the industry 2 years ago, 3 years ago, who were looking at changing the crop rule, and we were just all over the place, and we were trying to pull it all together under a single change, working with the Jockeys Guild. Okay, the rule itself that is in place is consistent with the work that we did in the Mid-Atlantic. We worked with all the stewards, we worked with the guild, we worked with horsemen, we worked with regulators, and anybody in the room who was in that process will tell you it was an exhaustive process. And then we started working with groups around the country. We had proposed a multiple whip violation system virtually identical to what we're doing with medication in the Mid-Atlantic. And, that's been probably the most successful program we implemented because I can go back 3 or 4 years, we've never had a multiple medication violation violator. So the system works. And so to encourage riders to comply with the rule, and the single biggest concern was if you didn't have a heavy enough penalty, there would be no incentive for the rider to obey the rule. You also have to remember in New Jersey, they were insistent that the use of the crop be eliminated totally. So there's a lot of pressure coming from different places as to what an appropriate rule should be. And then you have those who say, how are you planning to enforce this? So in order to get to a situation where there is a disqualification of the horse, it has to be a pretty significant situation. And that's no different than the multiple medication violation program. So that's why it's there. If you read it carefully, a rider is really going to have to be abusive. And look, I know you don't like to hear this. We have the animal rights people breathing on us every day. Every time there is a race broadcast nationally, we hear from them. So there are a lot of cross pressures that we and Lisa and Ann, they're all going to have to deal with ongoing with this process. You?
And Alan, if you don't mind, I want to make one more comment on the crop rule. Out of all the rules the medication committee deliberated over, this one probably took the most amount of time. The resulting rule is a balance between folks who were pushing for a no crop at all rule to folks who would have preferred a much more lenient rule and jockeys could shoot the horse more often. I can't tell you the hours that the committee deliberated on this, and the number of different rules I looked at from across the country, leaned heavily on the Mid-Atlantic because you guys have done a really good job there. Also looked at rules from outside of the United States, California, Oklahoma, Louisiana, all ranges of rules, and this is where they landed. But there is as Alan said, there's a group in in other factions outside of racing that would like to see the crop go away. And if, and again, as Alan said, you may not like to hear it, but they're there, and we need to address it, and we need to be careful that those folks aren't able to accuse us of things that aren't happening. And controlling the crop use is one of those things that we need to be aware of. Sorry, just need to throw that out there.
I have a registration question. So my wife and I were co-owners of our business, and we're both trainers. We're both licensed trainers. So in Pennsylvania, we have a division of horses there, and we're interchanging these horses. Like when I'm running in Maryland, they run in my name. When I run them in Pennsylvania, they run in my wife's name. How do we handle that? There's certain benefits that we have, insurance benefits, that won't allow me to run horses there and here. I get excluded from those benefits. So if we run them in my wife's name, then we're included in those benefits. So how do you handle that?
Sure. From HISA standpoint, we just need one name attached to the horse. It will not affect how your ownership is depicted in any state. So if you're running a horse in one state and that same horse runs in your wife's name in another state, HISA will not, your registration with HISA will not affect that. HISA just needs one name attached to a horse, someone that we can contact if we need to share information with you. And my battery is starting to go, so I am going to plug in a second, Alan, if you want to take the next question.
Yep.
Getting back to the whip rule, from a jockey standpoint, if he gets to the third phase and then you get to the fourth phase, is there a time limit? In other words, that penalty drop off after a year? Because you'd be a lunatic to ride a jockey if he's going to be facing as an owner. I would not want to ride a jockey that is into his fourth phase where the purse money would be lost. The answer to the question is it a 1-year deal? Is it a 2-year deal? Or is it a lifetime deal for the jockey on the whip roll?
And I'm so sorry, I was trying to plug in to get my power going back up. I'm afraid I'm going to lose the battery, but no, the point system is a cumulative process, and some of those points have an expiration period. So when a jockey reaches a certain point level or has a point level and hasn't had an infraction for an X amount of time, those points will go away. But if a jockey is at that point, the rulings against the jockeys regarding this, the violations, they will be posted and trainers will have access and know where the jockeys stand. I'm not sure I answered that properly.
No, you did,
So-
because as an owner, I think you'd be a lunatic to ride a jockey that's gonna, if you ride him and he hits the horse too many times, you're gonna lose the purse. So you're putting the jockey and the owner in peril. That's my opinion.
Go ahead, Jose.
But
Yeah.
the violation to lose a purse is per race. So it's not like they go into a race with more of a chance of losing a purse, if that's what you're asking. If a jockey's had some violations and rides a race, that race will, the only thing that will affect the owner in the race he's currently riding is whatever actions happen in that race, not prior actions.
Jose, let's do Jose in the back. We'll do you
I'm
next.
just gonna say something about, I don't hear anybody talk about jockeys or the riding part. I like to know who can make the rule. If any of the jockeys was the one to make the rules, by the whip or anything like that. Because you seems like you riding a horse, a lot of people don't understand the horse. A lot of horses need to have whip. If you don't have a whip, you're not gonna get there. You shit in the owner and you shit in the public, because the public depend on win, second, third, and fourth to get the superfecta or anything like that. And I think you eliminate the whip, like we was talking about, mom and part, or the shortest in the whip is in affecting not only the riders, not affecting the whole industry, the gamblers who are supporting the racetrack, the owners. I mean, the difference is from winning to second is a big deal in money.
Jose, if the whip rules, are a product of a collaboration among a number of groups and individuals in the industry, including the Guild, the horsemen's organizations, regulators, the Association of Racing Commissioners International, and international bodies. It has been probably one of the most intensive efforts to try to address the best way to respond to the animal rights groups, protect the horse, and ensure the integrity of the race. This was not some sudden decision made out of whole cloth. And actually, it was that the rule pretty much mirrors what we all agreed to in the Mid-Atlantic. But then the Kentucky Racing Commission adopted a virtually identical rule that the Guild supported. So this isn't coming from non-riders. The riders were intimately involved in the development of these protocols.
So this is back to the funding question. I mean, I've heard different things like there's going to be a charge per start per horse based on the purses structure at the racetrack. Some racing commissions have said, no, they're not going to pay the cost of it. So then is that ultimately going to fall on the horsemen? Is that going to fall on the owners? If the state, well, there's multiple jurisdictions that their racing commissions have said they're not going to pay. So.
Great question. So let's make everybody understand. The way the statute is written on assessments, in the first instance, when HISA bills a jurisdiction, let's take Maryland, okay? Maryland's assessment was about $699,000, okay? To be spread among all constituents, all covered persons. In the first instance, the determination of how to pay that was with the Racing Commission. Not that the Racing Commission was going to pay for it, but they were going to make the determination of how much the tracks were going to pay, how much the horsemen were going to pay, how much the jockeys were going to pay, how much the breeders were going to pay, how much the veterinarians were going to pay. Racing Commission said, we're not doing that. There's some jurisdictions where the commission has said, we'll take care of that. There are others who said no. In the instance where the Racing Commission says no, the racetrack is then deputized to make that decision. And HISA's thinking there was, because horsemen and the other stakeholders are engaged on a daily basis with the racetracks, that collectively an agreement would be made on how that money would be paid. Okay. And so that's what we've done here. If the track had decided, let's say the Strana Group decided, well, you know what, we're going to let the horsemen pay for all this. We're not going to pay for any of it. We would then go to HISA and say, they're not spreading the cost equitably. You need to step in. And we believe HISA would step in and say, guess what, Strana Group, that isn't going to fly. You either come up with a better formula or we'll come up with one for you. Okay. Now let's assume that we all couldn't come to an agreement. Then HISA would have the authority to make that determination and to ensure that money is collected. Now, we don't think it's we in Maryland didn't think it was in everybody's best interest to be hitting you all up with a per start fee or telling the veterinarians, oh, by the way, it's going to cost you X dollars and the breeders. We found a formula and a way to pay for it that doesn't impact you. Okay, so Maryland is paid. We're going to go through this exercise every year because there's going to be a budget. We're going to have to determine how to pay for it. And that's the law. And that's how it's going to be done. Okay. There will be our portion. We've got 70 some million dollars in the purse account. 300,000 will come out of the purse account to cover it from our share. I don't think you're going to notice it. It's not going to affect race days, race purses, or anything. Okay. Not going to affect a thing. That's 0.4%. If you want to be assessed, tell us and we'll create a per start fee. I don't think that that's the way you want to go.
Go ahead.
It is, but I think that what Lisa tried to explain was that when you get into the anti-doping program, for example, right now, drug testing in the state is paid for by the Strana Group. We don't pay for it. You put that all back in, maybe that won't change, but maybe HISA can find economies of scale where that money gets reduced. A lot of what we're currently paying for gets built into the program, so it's not added costs on top of what we're doing.
Lisa, you want to go ahead?
Okay, I'm gonna start. I've got a couple of quick questions. I'll kind of run right through them, but one that just came to mind was pertaining to the jockey whip rule and the strikes getting to where the horse is disqualified. Is that going to be determined before the race is official, or will this be known after the race is official? And are the stewards going to be counting strikes then and put an objection or an inquiry and determine that before the race is official?
Right. No, it will not affect the official order of finish. The stewards will call the jock in to watch films probably the next day or whenever the schedule is for stewards at your racetrack, and it will not affect the official order of finish. If when the jock is called in to talk to stewards, he'll be given an opportunity to explain to the stewards why he may have gone over the limit of 6. Perhaps there was a safety issue, perhaps, his horse is trying to bolt, whatever. If there's a legitimate safety reason for going over the 6 strikes, then the jockey will not receive a penalty. There is unlimited use of the crop for safety reasons. And I realize that that's sometimes difficult for a jockey to articulate that when sometimes you're on a horse and you feel he's going to do something and you want to be proactive. But the jockey will have an opportunity to explain that to the stewards prior to being assessed a penalty.
Okay, so you said it won't affect the official outcome of the race, but they will lose the purse. Now, will that affect a horse's purse earnings? I mean, this comes into play with graded races, and it's pretty important for fillies.
Yes, it will. And what I meant was official order of finish, not necessarily official outcome. From a mutual standpoint, it will not affect the official order of finish. From a mutual standpoint, if the jockey is found to have violated the crop rule and it's a class 2 or class 1 or class 2 violation, then the purse will be taken away from that horse. That horse will be placed last. Whoever was behind that horse will be moved up. So the horse that the jockey was riding will keep its condition depending on what type of race is in. And if the horse was first, the horse behind it will become the official winner for any black type or any other classifications your state might have for them.
Okay, and another question going along the lines of who has, I guess, the ultimate authority. Now, this goes back to the pin fire, 2 questions about the pin firing and freeze firing issue. First Racing sent out an email asking all trainers to send in a list of any horses that have already been racing or on the racetrack, that they want a record of every horse that is in that trainer's possession to be listed and be subject to identification before July 1st. Now, if I'm following correctly, it says that we're not going back from July 1st. So does First Racing have the authority to collect that information on horses that have previously been freeze fired or pin fired? Or since HISA is telling us that it's not going back, how do we handle that situation?
I'm not quite sure what First Racing is doing. I can just tell you from a HISA standpoint. Again, I'm sorry, I'm trying to get plugged into power here. That's why we're going all over the racing office. HISA's rules do not go into effect until July 1st. So if a horse is pin fired prior to that, and as Lisa said, it would be, although you're not required, it'd be great to have the records of that in the horse's file. That's what we're looking at. I don't know what First Racing is doing. But it's not based on, HISA is not asking them to do that. That's an in-house rule or a house rule.
And they have they do have the ultimate authority as in-house and giving us stalls here that they can ask for that.
Alan, you want to talk about house
Well,
rules?
the answer is you're on their property voluntarily. They give you stall space if they're seeking information. I don't know what it is they're looking for. If you'd send it to me, I'd certainly like to find out why it is they seek the information
Sure.
they're looking for.
And two more questions. One more about the pin firing. It said that they didn't have to be, if it's not a covered horse. So essentially, if I have a 3-year-old that's never run and he's on the racetrack, from what I'm gathering is they don't have to be registered. They can be registered at any time, but they have to be registered before entry time. So if this horse is a 3-year-old that's never started,
Has it had a time to work out ever?
yes.
Then it's covered. That's a covered horse. It's a horse that is 2 years old and has had an official timed workout.
So then that goes back to the whole thing about why we're not covering the sales companies, because
Because the statute doesn't provide for jurisdiction over sales companies. What the only part of the act that applies to sales companies is there's a provision of the statute relating to unfair and deceptive trade practices that if a sale, which would allow, for example, HISA to investigate and seek to prosecute violations of unfair and through the Federal Trade Commission, unfair and deceptive trade practices. Okay.
okay,
But
so that
that's-
would go under the, so that would go under the issue of, say, I buy a 2-year-old at the 2-year-old in training sale, and within a year of me purchasing him, this horse tests positive for bisphosphonates. How is that horse? How is that not under, how am I not held responsible for that? How am I?
Well, I mean, I can't answer that from the standpoint of how long bisphosphonates stay in a horse.
Well, they've already tested. I
Said
mean,
a year
there's
later.
there was a
But-
trainer in California that had one test within a year of having it with an older horse.
But look, that would be for HISA to prosecute as an unfair and deceptive trade practice. You could complain to them.
Okay, and just one more question, under the safety and welfare, of all the rules that are changing on the racetrack and going along with accreditation for our racetrack. I think that's a big thing for me. I'd like to know a little bit about the accreditation, process on our racetrack. And if we have an issue with any one of our surfaces or deem that our MJC, First Racing, or wherever, whatever racetrack you may be at, if we have cause for concern on issues that horses are getting hurt, breaking down, and they're very regular, how is HISA going to help us in that if we are not, if we don't feel like we're getting enough back from other racetrack?
Okay, good.
I think I know the answer, Ann.
Well, if you'd like to take it, go right ahead, and I can fill in if you'd like after that.
I mean,
But
I think
it's a
the
much-
answer is that HISA has jurisdiction over a racetrack safety program, including racing surfaces. There are specific provisions in the act regarding racing surfaces. And if stakeholders are not satisfied with the manner in which a track is handling track surface issues, they can complain to HISA, and HISA can step in and investigate through the committee.
And if you don't, let me get into the weeds just a little bit, Alan. I can't tell who's asking the question, but if you take a look at our rules, they're divided into 2 sections. One of them are labeled 2200 series and one is 2100 series. The 2100 series is all about accreditation. And we are asking the racetracks, there's a bit of a lift for them from a reporting standpoint to continue to report to us things like cushion depth, moisture content, to have a yearly survey. We will also send in, I think most of you people there know Mick Peterson, we're going to send in a team to every single racetrack and have Mick do a baseline of the base and the surface material. And one of the goals of HISA is not only to have uniform standards from a medication standpoint, but we want to try and have a more uniform surface standards. And that doesn't necessarily mean that every track is made up the same, meaning that, depending on where a track is located, it may be very, very hot, it may be very, very cold, but we want to be able to help the racetrack determine what materials to use and how to maintain it so that it feels the same to the horses when they get on it, and it is a consistent racetrack. But there are quite a few things that HISA is asking of each racetrack facility to report to us, and it will be those requirements will go towards their accreditation.
Thank you.
And with respect to accreditation, our racetracks are accredited under the NTRA safety and integrity code. That has always been a voluntary accreditation. HISA now becomes a mandatory accreditation. And there are many tracks in this country that have not sought accreditation. You can look at the current NTRA safety code. It's online, the NTRA website, to see what those code requirements are. A lot of what would be gray area issues in accreditation are solved by HISA, because under the NTRA safety code, the mere fact that a track would advocate for a change in a rule by a racing commission, and the racing commission wouldn't change the rule to conform to national standards, was all that a track needed to do to get accredited. Under HISA now, those rules will become mandatory rules, and so there won't be an advocacy requirement. But if you go through the rules, Maryland is accredited every 2 years by a team that comes in, does an inspection, makes notations, there are changes that need to be made. They work with the racing commission, and our tracks here are accredited. That doesn't mean you're not going to have problems, and we know what the problems are, and we try to deal with those problems. But to our credit, our tracks are accredited.
Is this on? Can I ask how HISA came up with the traction restriction? They're not going to allow tow grabs in the back after August 1st?
Sure. And actually the rule goes into place July 1st. We're just not going to enforce it until August 1st, because we heard from shoe manufacturers that they needed to build up their inventory on the 2 millimeter full rim. But the decision to on the horseshoe regulations comes from research-based data. Our commission chairwoman, Dr. Sue Stover, is the country's, if not the world's, leading expert on equine breakdowns, and she's worked with numerous racehorses and done numerous studies on what some of the causes of these breakdowns are. And there's research to show that anything above a 2 millimeter full rim tends to, and I am not a vet, so I'm not going to be able to speak that type of research but there's research that supports the use of nothing higher than a 2 millimeter, and that anything higher, or any grabs or any even in on the hind shoes, causes the horses to be more prone to injury. So the short answer is research dictated that rule being developed by or agreed to by the committee.
Thank you.
You're welcome.
I have a comment that Donna's going to help me out with. This is actually for Lacey. Lacey, in regards to the pin firing and the Stronach group taking the dates, that's actually to help the horsemen and the vets, because they want it documented that certain horses have been pin fired before July 1st, so that the vets and the trainers don't get in trouble for horses that are pin fired. So they're just trying to keep a list, in advance, so you know what I mean, to help you out. So did you have
Yeah, I
something?
was gonna say, from what Adam has told me, is as of July 1st, no horses can be pin fired or freeze fired. So the reason he, as a veterinarian, is not allowed to do them at a farm or anywhere else after July 1st, according to HISA. And the AAEP has not condoned pin firing for over a year and a half. That being said, the reason they're asking now is to make sure that it is documented that any horse that has been pin fired or freeze fired, that it isn't done after July 1st. So there's no trainer or veterinarian, anyone that's going to get in trouble for a horse that's entered to run the 1st of August that's been pin fired if he was pin fired before July 1st.
But my understanding that's not correct, because if somebody wants to pin fire a 2-year-old that hasn't done a published work yet, they can certainly do and won't be illegal. And that horse can come here next year and race and do his public work and do it. So allows people to do whatever they wanted to do until that horse become a covered horse.
But that's what I'm saying. He's been told that you're not supposed to do it at all after July 1st, and now they're saying it's not a covered horse. So there's a discrepancy in what they're saying and what they've been told.
We'll get it clarified and we'll get you the answer. Okay. Wendy, you had a question? We're gonna wrap this up soon, please, everybody, so we can get through this.
Hold on, everybody's got to have a microphone, Wendy. Hang on.
We have it.
Guys,
Wendy,
Okay,
hang on, hang on. You
Alan.
go next.
Yeah, hi, Al, thanks, for doing this. I just have a simple question. I think I know the answer, but a racing partnership, everybody in the partnership must register by July 1st. Every owner in that partnership,
if they're licensed.
if they're like every licensed owner, and there's no fee. Right.
And
okay.
Ellen, let me qualify that. If the partnership has a horse that's racing, only one of the partners needs to register as the owner. We don't need the partnership name. We just need one person. And if for HISA, if a partner owns 5% or less, they do not need to register. Just wanted to throw that out.
Okay, but so only one owner has to register.
He's the designated owner for the group.
Right. All right.
There has to be one person who gets notices from HISA,
Okay.
communications. They know who to
And that-
communicate with.
And that owner will be allowed to share that horse's information, but then the rest of the owners will need to be registered in order to have that information shared with them.
Okay. So only one. All right.
Wendy,
I think you need to, I think. That the horse cannot train for 48 hours? What
I didn't hear
can you
you,
clarify that?
the Magna Wave and Laser horse cannot be trained for 48 hours after being treated with a
Right.
Magna Wave or Laser.
And we're going to clarify that language. What the language should say more clearly, and I apologize that it doesn't, is that the horse should not be breathed or worked or, I'm trying to think of a better word for it, but yeah, of course, the horse can go to the track and gallop, but the horse can't be breezed or have a timed work or race within the 48 hours. So we need to, I understand that language is not clear.
Okay, thank you.
We're
for
gonna, and we're probably gonna re-engage with HISA on that issue. Because I think the concern about some of these therapies is that they have an analgesia effect. But I don't think that's the case with Magna Wave and some of these other therapies that are being done. So we're gonna revisit that issue with HISA to see if we can get that clarified.
Well, and are you talking, when you say Magna Wave, you're talking about like the blankets and the heat wave?
Yes.
Yeah,
Yeah.
the committee is meeting about that exact subject. And I know someone there doesn't like the word intention. The intention of the rule is if a therapy can hide or take away the feeling of pain from a horse, it's not allowed. If it's a therapeutic type of treatment, then it is allowed. But we need to clarify that language, and we know that.
Yeah, and we're gonna engage with you on that. We had that issue in New York and I think we worked through it satisfactorily. We're gonna re-engage on that. We're gonna try to wrap this up in a few minutes. Any
One more
final
question.
questions?
What-
Bobo,
Who in each state is responsible for the HIFTY safety regulations?
I'm sorry?
Who in each state would be the point for the HISA safety regulations?
I'm not
There was-
sure what,
The question is who in each state is responsible for compliance with the regulations, the safety
If-
regulations?
if you mean who isn't responsible for enforcing them, a HISA steward or the Board of Stewards, depending on, in Maryland, for example, the Racing Commission has agreed to work with HISA, so the Board of Stewards and the regulatory vets will be responsible for enforcing the rules.
And people in other states, where would they find that information?
If they're a racing commission in that state, and most states have, it will be the same. There are a few states like Texas and Oklahoma who have chosen not to work with HISA. In that case, HISA will employ a HISA steward and a HISA veterinarian to enforce the rules.
Thank you.
Welcome.
So to clarify on your partnerships, I have owners that own horses with me. They don't have to sign up for HISA at all, as long as they don't own a horse by themselves. I'm the acting owner of the partnership.
I think to get some clarification, Ann, real quick on that. They're licensed by the Racing Commission,
Yes.
They need to be registered. Okay, that's the point. I think that's the biggest takeaway. If they're licensed by a racing commission, they need to be registered.
Right. The point I was trying to make is only one of them has to be connected to the horse. That was my point, not all of them.
So let's clarify again. If you have
Okay.
if you have a partnership or a multiple entity group, one owner has to be the designated owner for that group. Any member of that group who is licensed by a racing commission has to register with HISA. Okay? It's that simple. If they're not licensed or not required to be licensed, they do not need to register.
Yep. Sorry if that wasn't clear. I
So-
apologize.
Is it correct that I read somewhere that you're all thinking about hair analysis on the horses
I wish I
for-
could answer that,
for
but
substances?
yeah, I'm on the racetrack safety side of the HISA. So I really am not the one to talk about anti-doping. I'm just not educated enough to speak to that. I'm
Well,
sorry.
well, it's a very slippery slope. I've used hair analysis for years on horses, doing chronic lameness cases. And I did read that somewhere that it was being considered on the anti-doping. So if we're signing on now, working on horses on the farm, return back to racing or whatever, it stays into the hair for 6 months to a year or longer. We use it for heavy metal testing on horses with thyroid conditions. And when I saw that came up, I said, well, we might as well just shut down. We're going to be jumping hoops constantly with you people.
Well, I
we
would recommend-
currently, we already do hair testing here on a random, not on a regular basis, but on a fairly regular basis, randomly. We're not looking for the heavy metals. We're primarily looking for clenbuterol and some other substances, those types of things. But it is being done right now, so it's nothing new. But where do you know that you're going to go with zero tolerance? We know that ethyl mercury flushes out of a system so many days, but it could reside on the brain, pituitary, things like that. We're hitting some gray areas here that it's very hard for people. My vet, I've talked to him about it, and you're kind of jumping hoops and slicing some thin lines there as to what you can do and can't do. Well, that's at this stage of the game, a year later, 6 months later, at this particular stage of the game, HISA has not developed a complete bans list or therapeutic medications or all their medication rules yet. They're not complete. That's still a work in progress. So how they address those issues is yet to be seen.
And if I could suggest, I would highly recommend going on our website and leaving feedback. Those rules are out there for public feedback now. We're looking for input like that. I would go to the website, provide your feedback for that particular rule or your concern about any upcoming rules, and let the committee know that.
Okay, I think we're about to wrap up.
I apologize, Alan. I have another group waiting for me. If there's a last minute question, I'd be happy to answer it, but I do have another group waiting.
Quite a few questions. First off, you guys said you'd give us all day. Well, you're cutting it short now. And again, as I told you, I've had plenty of questions. Turn that phone on. You said you give us all day, and obviously you're trying to cut us short now. And I
All right,
told
well,
you I had plenty of let me finish. I had plenty of
No,
questions.
I'm going to stay here. I will not
Pardon?
leave. I'm going to send someone else to the other group. I'm here.
Well, here, I'm gonna go back to the racetrack accreditation part, Alan. That should be first done instead of grandfathered in, basically. They had tracks that they're accredited have 1 to 3 years. As you know here, we've had issues with the track over and over and over. And that's where most of our problems are coming from. These horses coming off the farm as 2-year-olds generally start off sound. What happens to them is the racetrack ends up destroying them. But we pay the price as owners and trainers. So one of my questions are with the racetrack accreditation part, how many injuries or breakdowns does it take for a track to be unaccredited?
I can't answer that question.
I knew you couldn't, that's
I
why.
don't think they can either.
I
Well,
can answer
how
part of-
come you haven't established that? Go
I
ahead.
can address part of your question. So nothing's been grandfathered. Okay, that Alan is right that any track that is NTRA accredited now gets a 3-year provisional accreditation. That doesn't mean that HISA is not expecting them or requiring them to fulfill the regulations and the requirements of the regulations. They still have to do all of that. They still have to report all of the racetrack requirements that we're asking everybody to do. And HISA reserves the right and can come to that racetrack at any time and take additional measurement, soil samples. We can investigate horses that may break down or be injured. They don't get a 3-year pass. They're just getting a 3-year provisional accreditation, and we will be monitoring them just as we are monitoring all other racetracks, and they have to fulfill the requirements of the rules. So it's incorrect to think that they're being grandfathered or that they're getting a free ride for 3 years. And then the other part of the conversation I didn't hear because I was sending someone to the other group. I'm sorry.
Well,
Was there another part of that question?
yeah, I have a couple more parts of this question, actually.
Okay.
What are the standards for the racetracks? Meaning, how much cushion should they have? How often is it measured? Who checks this? I mean, I can understand they're gonna send data in, and then you made a comment about Mick Peterson, like he's the lord of all racetracks. Well, he was in here in Maryland, and if you're gonna go by all of his recommendations, I don't think that it's gonna work well in Maryland. I don't know about other tracks, but he didn't work well for us. So what
All right.
standards do you have in place that the tracks have to adhere to now on depth, type of cushion, material that they work with, maintenance of the track, all these things? I mean, I'm looking for it. I don't see anything but a vague summary of track maintenance and rails and starting gate pads and stuff that they do anyway.
Well, the
That's my
reason you don't see that is because there is no standards. And HISA through data wants to develop standards, but we're not going to come in and just pull things out of the air and say, this is what you need to do to have a safe racetrack. We need the data that the tracks will send to us to help us develop it. But it's only because no one in racing has done that before. So we want to start doing that. We want to start getting the data, giving feedback to the track superintendents, and giving information to the industry so they know what that data and that research determines. But there are no standards now because racing's never done that. And that's one of the reasons that racing needs HISA. We need to do that. We need to develop data and research so that we just don't have someone going out and sticking their finger in the track and saying it's deep enough, or we don't have someone go smushing in water and saying, oh, it's too wet to ride. Those are not the smart ways to make safe decisions. And I can't answer your question because there is no safe standard. But there will be, as soon as HISA can get enough data to develop them, there will be standards, and racetracks will be held accountable to adhering to those standards. We just don't have them yet.
So one of the most important things to the horses and the horsemen and the jockeys is the racetrack surface. And you're more concerned with getting everybody signed up because you don't have the standards and you don't have the people in place to be able to make any good recommendations. And we're not going to depend on Mick Peterson in Maryland. I don't believe most of the horsemen have no confidence anyway. So
And can I,
go ahead.
is your name David? Is that correct? I just
Dale,
wanted
my
to
name's
direct.
Dale.
So
Dale.
Dale, my name, all right, Dale. I'm not sure I articulated myself very well, so I apologize if you didn't get what I was trying to say. But the industry for the last 100 years hasn't developed the standards. You don't know the standards. Alan doesn't know the standards. I don't. There are no standards because there hasn't been research to develop them. We can't pull those out of the air, and we are not spent. These rules for accreditation go into effect July 1st, and we are asking tracks to implement this as quickly as possible. We don't think Mick Peterson is a god, just like I don't think you're a god, and I hope you don't think I am. We think Mick Peterson can help train some of the track maintenance staff and the track superintendents on how to report the data that we need in order to do research. And he is going to help us do that. I'm not saying he is the guru of racetracks. I'm not saying there is a guru of racetracks. If there were, perhaps racing would have taken it upon themselves years ago to do this. But it didn't happen, and it's going to happen now. I'm sorry, I can't hear. If that's a question for me, I can't hear it.
Comment is that with climate change, surfaces
No.
are going to change, conditions are going to change.
Not climate change, but where you're at, the region that you're at, whether you're in 90-degree Florida or you're racing up north and it's, 5 degrees out. So how are you going to develop a standard for all racetracks? And we do collect lots and lots of data because for as long as I've been training, every time you've had a horse breakdown, you get interviewed by somebody from the state vet's office. What happened? How many times did this horse run? And for the last several years, we've been turning in all of our vet works as of our vets here in Maryland. So where's all that data going? What's being made of
Let
it?
me go. Let me address your first question. When I say standards, the standards would be for each different racetrack. Of course, you cannot treat a racing surface in Belmont surface the same as you would at Gulfstream. California, Texas, the weather conditions make a difference. The availability of material for the track surface makes a difference. The base of the track, the equipment, all of that makes a difference in how a track is maintained and how what the surface is. The goal is to collect data from all of the racetracks and analyze it and put it together and help each individual track develop standards for themselves that even, I'm not going to articulate this very well, but the data will tell us what compression and what depth and how much moisture is best for horse safety. And then the data that's sent in from the tracks will help us determine how to get to that point at each different racetrack. It might be more water in one state, less water in another, maybe different material. It may be, we don't know what it is because the data hasn't been there to do the research. And regarding the second part of your question, if you've been collecting data regarding breakdowns, that's great. We want that, but not every state is. And that's, again, where HISA comes in. Now, every state is required to do that. So we'll have data from across the country to help determine best practices that we'll feed back to you. We're not going to say, hey, trainer ABC, you had this horse breakdown. This is what you did wrong. That's not our goal. Our goal is to say, hey, trainers across the country, here's what the data has shown us. Here's information that you may want to know on how to train your horse. You can take it or leave it. But we're going to give you that information to help you become more informed and be more aware of what these research projects are saying, and giving you tools to help you become better trainers, giving management tools to be better operators, giving jockeys tools to be better riders.
So where does the national breakdown average come from if all this data is not being collected? Because that's very important when you're sitting there. I've been in board meetings and you're discussing, you go back and you look and you want to be under the national breakdown average. Where is that coming from?
That is coming from the data you're providing. That isn't telling you why they're breakdowns. What it's telling you is how many breakdowns there are. But that is coming from each racetrack that reports it to the equine database, equine injury database.
The information is reported to the Jockey Club's equine injury database. And almost all racetracks in the country are reporting their fatality statistics. What we're doing in the Mid-Atlantic is we are taking each jurisdiction's information, fatalities during races, fatalities during training, fatalities that might be of a medical basis as opposed to musculoskeletal breakdown on the track. And we're digesting that information. We're looking at it on a track by track basis, on a jurisdiction by jurisdiction basis, on a regional basis, and on a national basis. And what we're trying to do, and it's part of the Mid-Atlantic Strategic Plan, is try to identify risk factors that we can educate horsemen on to identify horses that may be, I'm not trying to answer your question, trying to identify horses that may be at risk that can be identified before they go to the starting gate. And we've done a pretty darn good job. And we're trying to get that done nationally now through HISA.
So earlier in our discussion, she said the basis for the 2 mm toe grab, the shoe rule change and everything is based on their research. So then when Dale asked this question about the standard, then she said, oh, well, we don't collect national data. So it's all very conflicting each other.
There
Well-
is, but
I'm
there
sorry.
is- Yeah, I think you're mixing apples and oranges. There is no national database of information that would be critical to the best interest of this industry going forward. The statute requires that we establish that database. And beginning probably within a year, there will be standards and information that will have to be inputted into a database that will help to inform us going forward to make our racetracks and our environment safer for our horses. Okay? That's a critical component of HISA.
Alan, I have another question. Who has the power to scratch the horses if July 1st, the owner's not registered, trainer's not registered, his horse is in? Does HISA have the power to do that? And what if the racetrack says we're going to let them run?
I'll let Ann answer that.
Okay.
one.
Okay.
I'm sorry. We'll let Mike do it. I'm sorry, Ann.
It's pretty simple.
No, I don't
We've entered into an agreement with HISA, the Racing Commission has, that our stewards will make their best efforts to enforce their rules. So therefore, the stewards will have the authority to scratch your horse.
So the stewards will scratch them automatically. That's why I'm trying to figure out, because what if you're at a racetrack? This one would never do it. But if you're at a racetrack and they said, you know what, we're paying our dues, everybody's doing that, but if you guys aren't signed up, you can race anyway.
then-
I would expect that.
Is
most-
there a law, a rule on
Ann,
that?
can you, answer?
There,
Yeah.
If a track
There-
permits an unregistered owner to run?
If a track purposely lets an unregistered owner or trainer or horse race, then the track would be sanctioned if they did that intentionally.
So where in your code is that under rule, what number? Because I couldn't find it. I looked long and hard to see what sanctions it would be in place if that were to happen. I couldn't find it. So
Well,
where do I
the
find it?
sanctions themselves are, I believe, in the 8,000 rules, but racetracks have to be registered as well, and they have to agree to abide by HISA's rules and regulations. And
So-
enforcing our rules and regulations are what their stewards are or what they're agreeing to do, either the state or whether it's an association steward. So the steward's job is to enforce our, meaning HISA's rules and regulations, and the track would be agreeing to that as the state has already done.
And they'll go through a disciplinary process that they're entitled to, just like you
Yep.
are.
Yeah, because I
Just
looked for that to
providing for
see, I'm just always curious on what if, and what happens if so-and-so doesn't do something. And I usually go with what I read or find somewhere in print, not they can sanction them and fine them. So it would be a first offense, would be a first day of racing, or each horse that they let run. I mean, how would you distinguish that? Because I could see that could probably happen somewhere.
That would
Well,
be.
it's-
Go ahead.
Go
Ann.
ahead, Alan. I'm sorry. Go ahead. Go ahead.
You're more informed than I am, but they would be subject to a hearing and a sanction for violation of a HISA rule. Okay? And you would think in most cases with the racetrack, it won't be a suspension because then there's no racing, so it'll be a fine. And there's authority to impose significant fines under the approved rules already. So that would be a determination made by an arbitral panel or a steward or whomever, or an administrative resolution between the track and HISA.
And let me explain how the track would be aware that someone's not registered. So HISA is interfacing with the Encompass system, which the racing office uses to take entries. And when an entry is taken, there are what's called can't race flags. If you enter a horse that's on the vet list, a can't race flag comes up. If you enter a horse that a trainer has an outstanding fine, a can't race flag comes up. If you now, starting July 1st, if you enter a horse that isn't registered with HISA or the trainer or the owner isn't registered, a can't race flag will come up. So the racing office is then aware that the horse is not registered and can get with a trainer and say, we can't take your entry until you've registered.
Hello. I came here just like many of the other trainers here
trying to get a better understanding of HISA and how we're all gonna sign up for something that's ultimately gonna change come January 1. But I did hear some good stuff here about this oversight of the track. And obviously, we don't have the perfect person in place yet. And we all know our track here that, I mean, we had to redo it. I mean, just like California had to redo theirs after their 30 breakdowns. And I just, you know, I believe has to be an admission of guilt from the racetrack because obviously the track surface was bad, right? So I just don't like the pointing of the finger at the horsemen. Now we're talking about the breakdowns with shoes. We can't pin for our horse. All these things that we've done in order to prevent things from happening or try to make the better of a horse in order to, of course, have the best results. And in saying that, I mean, it's like changing of the shoes or whatever. It's like, you know, like what kind of bit was he wearing when he broke down? It's like to a horseman, we're like, surface is key. I mean, that's one good thing that I did see coming out of this, but the ultimate thing that I don't like in this whole conversation is like, it's so like you said earlier, ABC trainer, this is how you can train your horse better with this information. We're all have that where, you know, just some hesitancy to everyone in here.
So let me, I don't think there's a person who doesn't hear you when you say that. And so do we. And so do we. And we have a responsibility to this sport and to the future of this sport, which has been extremely challenged over the last decade. And anyone who doesn't see that has their head in the sand. Okay, we're trying real hard to save this business. Okay, we're trying to make it better. We're trying to make it safer. And we're trying to do it in a way that doesn't make it that much more onerous on any of us. We're all in this together. Now, with respect to the situation that we went through in Maryland over the last year, we have a mortality review process that we started that allowed us to identify why horses were breaking down last year. Historically, it was always the horseman's fault. And that was always the starting point. Oh, they must be drugging the horses. They must be doing this. They must be doing that. The mortality review process that we have that's been built into HISA allows for a much broader review to determine the cause or causes of fatalities and try to stop them, which is why we went through this painful process of trying to get the racetrack right here. Now, there are other forces at play here that I think are going to get our racing surfaces straightened out. And I've said this, I said it to Jerry Robb a couple of weeks ago, I said to others, I think that process is going to be more effective than working through HISA. And that's no criticism of HISA, but we know that's a priority here in Maryland. But the good thing about HISA is that the finger isn't always going to be pointed at the horseman, because for the first time, the racetracks have responsibilities, and the racetracks are going to be held accountable if they don't fulfill their responsibilities. We don't have that right now. There's no mechanism for that. So we're all in this together. And look, and we're going to close out. I don't think there's anybody who doesn't think that there's going to be a bit of a bumpy road when we get started. Lost us again. Okay. I don't think there's anyone who doesn't think that this is going to be a bumpy road, and we're going to have to work through it. We're going to work through it together. The MTHA, as they've always been, is going to be an invaluable resource. I know I'm going to commit whatever time and effort I have to make it work, because I think it's in the best interest of the industry going forward. And quite frankly, we don't have a choice. We're going to work with our regional groups with the THA. We're going to work with national groups. Our ambit has already expanded to Florida, California, Kentucky. We're going to work with HISA because we have a seat at the table. They talk to us. They're listening to us. No, they don't do everything that we ask them to do. I wouldn't expect that. But I think we've already made a difference in the work that we've done. We know it from what we've done. You may not see it or at your level, but we know it. At the end of the day, they're not here to be the whipping boy. They're here because they've been handed a responsibility and they want to be an asset to the industry. And if you approach it that way, then those few individuals who just see our industry differently and see an opportunity, they're going to get singled out. And the rest of us are all going to be part of what I think is going to be an improvement to the industry that we will look back and say, you know, we did it. We did it at the right time. We did it for the betterment of the industry. We have a better public image. We're doing better by our horses. And I think we'll be looked at differently. And I think that's what our goal should be. So with that, you know, we're all available at any time to answer questions. I know that Ann has been incredible, Lisa Lazarus. The reason why they're not sitting here for 3 hours is because there are other Zooms going on across the country right now, the same kind of meetings we're having. We're trying to get the information out. We're trying to hear your concerns. We're trying to deal with your concerns. We're trying to be respectful. But, you know, come July 1, you know, there's a new sheriff in town and we have to learn to live with it until somebody tells us we don't have to live with it. So because, well, like the question was, why are they so willing to talk about things now when they weren't before? And that's quite frankly not an accurate statement. And this is the last comment. Yeah.
I just think that the horsemen are frustrated because this is being like rushed along. You know, some people feel it's being shoved down their throat. And, you know, I think a lot of people were in denial that this wasn't going to go into effect. But now the public, you know, they want to have our public comments on the medication part and this, that, and the other, but not a lot of time for public or working out, and like you say, massaging the rule, changing the rule. So everybody's obviously got their hackles up, and, you know, some people and are alarmed. And listen, on a whole, I think all the horsemen here love the horses, love the industry. If someone's cheating, we want them out of here. Absolutely 100%. Nobody wants to get beat by a cheater, but we just want to make sure that we're all going to get the same fair and nothing, you know, they want to know what they're signing up for in black and white without all, oh, well, this has to be changed or this rule's not done yet. And that's understandable.
So let me answer it this way. There were 3 previous iterations of a federal law called the Horse Racing Integrity Act. It was promoted by the Jockey Club. And I remember I testified in the hearing before Congress in opposition to that bill 3 years ago. That bill was medication only, would have been extremely onerous to the horsemen, and would have put the United States Anti-Doping Agency in charge of medication. And I can tell you, it would have been a nightmare. And what they wanted to do was shoehorn into horse racing the manner in which they oversee human sporting events, and they don't dovetail. Okay. I think the pressures from the fatalities at Santa Anita, and clearly the Service Navarro situation, it didn't matter how good we are in Maryland. The fact of the matter is there were forces at play that forced Congress to step in. And what we said to Congress was, if you're going to regulate in this area, don't just point the fingers at the horsemen. This is about horses dying on the racetrack. And if you want to do that, you have to build in a safety program. And you have to take the United States Anti-Doping Agency's control out of it, which we succeeded in doing. The racetrack safety program is what we are doing in the Mid-Atlantic with slight changes. That's why I keep saying, I'll say it again, it's not a heavy lift here because they're going to be doing what we're already doing. So nothing's being shoved down the throats of horsemen. There aren't major changes coming. I know everybody's concerned about registration because they think that Pete is trying to get the information, or we're going to expose people who are immigration violators, or we're doing this. They need the information. The statute requires it. It's basic information that they need that, quite frankly, if PETA or anybody else wants it, they can get it elsewhere. It's not like you're giving anything up. Okay, they've got to, Dale, they got to get people into the system. It's required. So nothing is getting shoved down anybody's throat. The registration opened 30 days ago, and that's what we're doing right now. Okay, the safety program is going to affect on July 1. We're already doing it. And the current medication rules are in effect until January 1. And what those changes are going to be, you're going to know about it well in advance. And I don't think they're going to be dramatically different. So I know nobody likes it. Nobody's going to stand on the table and cheer that we're doing HISA, but it's here. And so we're going to work with you. You need to work with us. We have to do it. We're going to try to make it as painless and pain-free as possible. And that's the only thing we can do.
Well, I just want to make one statement, because I think most of us, the reason we're here for, and we're glad you guys took the time to listen to us and help clarify a lot of the questions they had. And you know me, I can be a pain in the ass with questions, and I'm persistent, but that's just my personality. But the main thing that most of us are upset about is we see a lot of things that aren't there. As you heard me at the MTH meeting yesterday about approving stuff that you don't even know what's in there. That's why we're asking adamantly for you, Lisa, everybody else, to try to push this back to January 1st implementation. We know it's coming. Let everybody be able to understand exactly what's in there. Because to you, you don't think it's much of a difference. But when you really read through it, there's things that seem to be different to us. And no one seems to be doing that. So you sit back and wonder, well, the government doesn't get anything done right or on time. This is so important. Why is that? I mean, is Lisa getting a big bonus if she gets it implemented July 1st? Is she get a big job somewhere else? I mean, my question is, oh, Alan, you can frown and make faces and all that, but knowing how the government works, they delay everything. This is like, if you don't drop dead date is July 1st, or that's it. That's why the people are here saying, look, we're not ready for it. You're not even ready for it. Can't we try to push it back? And I know you say it's almost impossible, but you know what? In racing, a lot of things are almost impossible, but Rich Strike won the Derby too. That was an impossibility, right? So, I mean, my point is, we like you, we love you, but we want you to try to do that for us. Don't tell us that you can't. The same with Lisa. I mean, because it can maybe be done, but that's where we stand. I think that's the point that you're missing.
Point well taken. Point well taken. I wish I could tell you that there is the possibility of moving back the implementation date. I don't believe that to be the case. And I don't believe that there's anything that I can do to change that. If I thought I could, we'd be doing it. Okay. And don't think there haven't been efforts directed at trying to do that previously. But the fact of the matter is that between now and July 1, the ability to do that, I don't believe exists. But that doesn't rest with me. I can beg Lisa, I can beg, you know, Lisa works for a board. This is the management team. They are not the board. There's an authority board that is responsible for this. And if they want to, or they want to seek additional FTC consideration, they can do that. I don't believe they believe that that's going to be the case. We'll follow up. That's all I can do.
Lisa, I was thinking make her life easier.
It would make my life easier. I would love to have more time to implement this. You know, I'm going racing office to racing office and trying to educate folks about the rules, exactly what we're doing here. And, you know, I hear the same thing. Give us more time. And I would love to do that. And we'll do a better job if we had more time. But the law says July 1st. So that's what I am focusing on.
But that's all we're asking, because it would make your job easier and would work better if we could all work together to try to get it pushed back. In the meantime, you do what you have to do, you do your job. But I mean, I don't feel like you would do anything to try to push it back, or you're trying to, because you can do two things at the same time. One, try to implement it, and then you could admit to whomever you have to, whoever the higher ups is, hey, we're working our tails off and we're still not there, and it's going to be very difficult to be there by July 1st. Can we extend it like we did the medication to shoe rule? That's all we're asking for, is someone to do that for us.
I would hate to get your hopes up and put off registering, because I like Alan, don't think it can be done. I have been told it can't be done. Doesn't mean I can't ask again. But I would not want to slow any of this process down and get anybody's hopes up because I don't think from what I've been told that it will get done. Doesn't mean I can't ask, but if I were, I wouldn't want a trainer to be excluded from racing because they thought that this was going to be pushed back because I really don't think it can be.
We
Just
understand.
past putting that. So register today.
So we're going to wrap up. I want to thank you all for coming and being respectful. We will be doing a webinar probably within the next week on the safety program. We will advertise it, make sure everybody knows. We will have qualified people on that call to talk about the safety program. We'll also talk about continuing education. So that's what's planned. And then as we go forward into the fall, we will be doing webinars on the medication rules. So I don't think that there will be any situation, particularly since you're aware now, you can go to the website and look at the first draft of medication regulations that you can't say that you didn't know. So we're going to begin that conversation, and that conversation will go into the fall. That's it. Thanks, everybody.